So for those who are uninitiated, I'm Christian Ross. I own Ross Title and Ross Law, together with my dad, Don Ross. It's just going to be me today, but I would encourage you guys to participate, raise your hand, ask questions. But a couple of things that I wanted to point to kind of use for today. I actually want to talk about two different topics. So number one is new builder contracts. They are brutal. And they still have a lot of leverage over our buyers. These construction was really hot for the last couple of years, and you kind of had to agree to whatever the builder made you sign if you wanted even an opportunity to buy something. And the price would go up every week. The builders just seemingly they couldn't raise the price high enough. And one of the downsides of that is that you don't have much negotiating power. And over the last 3 years, in my opinion, these builder contracts have gotten more challenging because of that. They're adding sections and pages that are all builder friendly. They're not, if I compare it to maybe a NABOR or FR contracts, those contracts are realtor friendly. They are designed by realtors to help keep deals together. And then secondarily, they're meant to be fair for the buyer and seller. They're meant to get to the closing. And if you remember, my motto is get it under contract, protect your client, get it closed. I would propose that these builder contracts, they don't have that same motto. These are meant to get it under contract and close, and I suppose protect the builder. That's the change, is meant to protect the builder. They don't protect you, they don't protect the buyer, they protect the builder. Let's talk about a couple of reasons why I feel that way. Number one, the first page looks very similar to what you would see on a NABOR or FR contract. You've got purchase price. You probably can't see much of this. It might be too small and blurry. But you've got purchase price and deposits and things of that nature. Number one, they ask for a 10% deposit usually, sometimes even more. And then on top of that, they're going to ask you to pay for any upgrades out of pocket. So if the starting price is $600,000 and you've got maybe $100,000 lot premium, now it's a $700,000 property, and then as you do your design selections, you might have $100,000 in upgrades. So that $600,000 property is now an $800,000 property. On top of that, in the fine print, they're going to add a lot of fees that you normally would not see. Number one, most of these builders have the buyer pay a builder fee. Depending on the price point, it might be a $1,500 builder fee or a $2,500 builder fee. It's something that they can kind of slide in without many people noticing, but it has real consequences. $2,500 builder fee it's a lot. It is, especially when you thought you were paying the purchase price. Secondarily, they're going to switch some of the more traditional buyer or seller paid fees, and they're going to put them all on the buyer. So a great example is transfer taxes on the deed. So on a NABOR or FR contract, the seller typically pays for the transfer taxes. And transfer taxes, as we talked about in last week's seminar, are $7 per thousand. So on $1 million deal, you've got a $7,000 bill for transfer taxes. Seller normally pays that. You might just make that assumption. The seller pays that. The buyer is going to make that assumption. But in a lot of these builder contracts, they just switch it and they make that a buyer paid thing. You barely even notice. This is a 16-page contract. Gray out that. It's a 16-page contract, and it's 2 columns. And it's super tiny. It maybe is like an 8 size font or maybe a 10. It's really hard to read this thing, and they don't send it to you electronically. Sometimes they'll fax it or they'll make a copy, and it's a little blurry. I think all that is a little bit by design, because the less you can read, the less you can fight them about it. So transfer taxes could switch over. Just in those 2 fees, you're going to see a significant increase in price over what you thought you were going to. It could be $10,000. Now, the hard part is if you knew up front that it was 10,000 more than what you normally would have paid, you can probably rationalize it. They've got you in the sales room, you want to buy it, and you're like, hey, it's 710. That's the real number. It's 810. That's the real number. The buyer would you probably still sell houses. But they don't do it that way. They hide it in the fine print. And then 8 months later, when the house is actually closing, then you get hit with it and you're frustrated and angry. And so your job is made exponentially harder because your buyer all of a sudden feels like they were deceived. And most of those builders or buyers will not blame you, but some of them do. And I think that's particularly difficult. So we have to build some strategies in helping you avoid that. I don't want anyone to be able to point the finger at you and say, why didn't you tell me? I've certainly been in that position myself where a good example on typical deals is, maybe a special assessment that was passed, but is not yet due. So I remember working with a seller, and I was just trying to help. There were no realtors involved. And so the seller said, hey, here's a contract, can you look at it for me? And I did, and I gave it, and I said, look, you've got owner's title insurance. This was a Lee County property. Owner's title insurance is going to be paid by the seller. And I gave her the price on the, it's $1 million deal. You've got about $5,000 in title insurance costs. So I told the seller, I said, look, this is the one thing I can really point to in this contract. Otherwise, it's fine. You're going to be obligated to pay title insurance. She goes, that's fine. The net is what I wanted. We're good. I said, great. Well, fast forward about 30 days, there was a special assessment that she, I didn't know about. She probably did, but she thought that it was not due because it was actually due like the next year. But per the contract, seller had to pay that because it had been finalized. We knew who was paying it and was on our estoppel letter. So it was a seller cost. She blew a gasket. She was really upset. She felt like, she should have known this. She never would have agreed to pay title insurance and this. And it just soured the whole deal. And I'm sure you've been involved on deals like that. And, if I were to take a do-over, that's one of the things that I want to avoid at all costs. Is I need to make sure that I have some sort of checklist and I'm going through it and saying, hey, well, what about this? Are there any special assessments? Or what about this? Title insurance, transfer tax. Is there a mortgage? Is there not? Who is the buyer? Have you seen proof of funds? All these things that I've seen go backwards on me or blow up a little bit. I don't want that ever again. So on new construction, I feel the same way. And when I ask people to send me stuff and to, when I'm asked to help a buyer who's not using me for title, some of them question it. They're like, well, why do I need Christian to look at this? And, there's no hard sell, especially when, you might be obligated to use the builder's title company. But there is a lot of value in hiring me for a review and to basically hold your client's hand through the process. I don't charge very much. It might be 500, might be 1,000, depending on circumstances. It depends how much time I need to spend with the buyer. But I use it as an education because I don't want it to blow up in the buyer's face. I don't want it to blow up in your face either, especially if you're doing, 1 or 2 new construction deals in a whole career. You just don't know what to look out for. So cost is the first thing. A further example of cost that is somewhat hidden is you sign the contract, you go to your design center, the buyer says, well, I want this type of pool screen. And the builder says, we don't do those. Those are done separately. And the cost is, this is a real example, the cost is $25,000 for the pool screen. And so the buyer's just getting over this new bill. Now we're $25,000 above where we were before. And then the builder says, well, you can't get a pool screen for at least 6 months. So by code, you're going to have to put a temporary fence around. And the buyer says, well, how much does that cost? He says, well, that's $10,000. And the buyer starts losing their mind. This happened to me this morning and yesterday, where it wasn't the cost. It was that the hits just don't stop unless you do your due diligence up front. So cost is a big thing. And I would never leave that off of my checklist of discussing it with the buyer. If I'm at the sales center and there's a hard sell. I want to have an opportunity to sit with my buyer and go over the cost and say, look, here's how it is. It's non-negotiable what these costs are. This is what the deal is, but you just need to know, you need to be educated about these costs. It's really empowering to say before you sign, before you write the check, something like that, this is your cost. And you can say, look, I can't do anything about it. It's take it or leave it. However, you're going to have a better experience if you educate them about it up front, as opposed to them finding out about it later. In fact, to that point, my dad has made a career out of giving people that same advice. Educate them up front. Don't let them find out on their own. Because if you let them find out on their own, they're going to start blaming. When they point that finger, it just doesn't stop. It can burn right through you. So cost is huge. Now, the other things, in my opinion, are a lot simpler, and they're maybe even a little bit more obvious. Construction delays is the big one. Yes, everyone knows, anyone that's watched HGTV or been in this business for more than a couple of minutes knows that new construction might have delays, renovations might have delays, might have budget overruns. What they don't realize is that in a lot of these builder contracts, there's no end in sight. Here's what I mean by that. I don't want to spend my time looking at the contract, but this contract specifically, I was reviewing it last night, says that the closing date on the contract is simply an estimate. And then it talks about force majeure events, inventory issues, labor shortages, municipality deadlines or stop work orders. And it says none of these things are the fault of the seller, even if they are. And that your closing date can be unilaterally extended by the builder indefinitely. Now, most builder contracts have a deadline. They'll say no later than 3 years, but that's kind of brutal. Even a 3 or a 2-year deadline is really tough for a buyer to understand. When they were given a closing date of summer 2023, and now we're 6 months after that, or let's say it was summer 2022, and now it's December 2022, and we're 6 months delayed, and we're still waiting on these items. And now we're going to miss the season. We've got obligations for the summer. We're not going to be able to enjoy it. What can we do? That's the question that I always get. What can we do? What are my options? And usually the buyer has no options. The seller can unilaterally extend closing using this, indefinite closing date, this estimated construction date. If the buyer knows about that up front, it's an easy conversation to have with them when the delay comes. What I've seen multiple times here in Naples is that the sales agents for the builders make promises that they don't realize are lies. I don't know if I'm saying that correctly, but the sales agents have very limited information. They are kept in the dark by the builder, I think on purpose. So they will tell you, oh, we're selling these like crazy. We're not in delay. Everything is on track. You are on track to close fall of next year. And the buyer takes that at face value. But the reality is they're not held to that. Once they sign the contract says there are no reps and warranties that were agreed to verbally prior, that everything is merged with this new contract, and the builder can't make guarantees. And so all that is lip service. The builder's going to protect themselves from delays and things of that nature. That's really tough, but you tell them up front, it makes the conversation later easier. One thing that I've had success doing is pushing back on having a definitive deadline. So if they're telling you that the closing should be done or that the construction should be done in summer of next year, say, I want some sort of deadline where if it's extended beyond December of 2023, that the buyer has the right to terminate. And the seller or the builder may not agree to that. That's fine. I mean, I would love it if the builder agreed to it, but what it does is it pushes that topic into the conversation. It forces the builder to respond, and it forces the builder to be honest with your buyer, to say, look, we will not agree to that. However, here's what I can show you. Here's how I can assure you that we're on track. Here's all these things. That's really key. But I have seen a good amount of contracts where they'll put that in there. So if you have a builder contract that says it's a 3-year deadline for the builder to do this construction, usually I can get that down to 2 years. And then I feel like I've driven a lot of value. And, if I did that off of your recommendation or your referral, then I've driven value to you and your clients. So it's a really powerful thing in that sense. The other part of this is kind of something that you might expect. And that is, that design changes, choices, availability are very limited. You may not have that sort of flexibility. You may not be able to see much of the the things that you saw in the model home. And the model home is just an example. It's no guarantee as what's available. All right, so my dad actually put a question out here. He asked me to point out the recession. I think he's talking about the rescission period, where you have the right to rescind. So that is a good point. I believe I know what he's talking about. In a lot of these contracts, you have like a 5, 10, 15-day period to comply with Florida statutes regarding condos or HOAs, where the buyer has the ability to review condo docs and things of that nature within a certain time frame, but it's very limited. I think with condos, it's 15 days. I'm not sure what it is with HOAs, but these are new construction scenarios. So that's huge. If your buyer gets really riled up and wants to sign something that weekend, I think that's great, knowing that they probably have, likely have the right to terminate later, given that statutorily protected period to review HOA and condo. A lot of times the builder will even reference that in the contracts. You want to look for that in there. My dad also recommended an inspection company doing walkthroughs if permitted. Helps with a punch list and 1-year warranty. So that's true. I think inspections are huge, especially if you can negotiate it into the contract at certain timeframes. So most of these contracts specify that you can't be on the property, not without written permission from the builder, because they don't want you interfering. You don't own it yet. They don't want you messing something up. So if you negotiated some sort of addendum to the contract saying that you'll be permitted to bring your inspector at 5 different points throughout the construction, so that we know that it's moving along. Very powerful. It's helpful. And the more you know type thing. It also is very helpful if you have multiple draws, if the builder's requiring that you put money down throughout the process. It's definitely a value add. And then even if you can't do those things, you do have that final walkthrough period. So usually the CO is issued by the county or the city, and then you're supposed to do your walkthrough within 7 days of that. And if you can bring an inspector with you and negotiate that in advance, that's very powerful, because it's contractor to contractor negotiating, not some contractor bullying the buyer into saying, oh, that's normal, that's normal, that's normal. I think you have to be careful about saying normal if it's not normal. And so having more firepower is better. So that's our construction contract. And really, I felt the need to bring some of that stuff up because, again, new construction is still very prevalent. I drove down Livingston, or maybe it was, might have been Rattlesnake Hammock. And I mean, the new construction was outrageous. It's every property that's available is being built for new condos or new single family homes. And so the likely scenario, especially with the tight inventory, is that your buyers are going to be drawn to look at those new properties. And you want to have some sort of heads up. It's not the same as doing a resale. You can't just trust that the contract is fine. You really do need to educate yourself and educate your buyer. So even if your buyer is not willing to hire an attorney to review it, call my dad and I. We offer help in that scenario to you as the agent, because I've even if I'm not doing the closing in that scenario, if I've done closings for you in the past and we'll do them in the future, I want to help you with your buyer. I don't have to make money on every deal. I want to make sure that you are protected and that your business is protected. And if that provides value, I want you to call. I want you to ask me. It doesn't take me very, very long to go through some of these documents, because I know what I'm looking for. And so does my dad. We've done it for quite a while at this point. All right, so that is first step. And I would welcome anyone to give me some feedback. I'd love to know if there's something different that you guys are working with on new construction, condos or HOAs, single family homes. I will tell you that it is very normal for a long construction period, 1 year, potentially more. And it's very likely that emotions will fray at certain points in that 1 year period. You know, we're very lucky in that most of our clients get to know us and work with us over like 1 or 2 months. And then they're in their house or they're moved on, and, you know, we can't disappoint them anymore. We can't, you know, it's a very time limited period where we get to perform, get them what they wanted, and then kind of back off a little bit. I think it helps with relationships a lot, but on new construction deals, it's a protracted period that you're with your client, and they have the opportunities. They'll see the best in you and potentially the worst in you. And so you have to be very careful on these types of deals because it can get you in some trouble. All right, deep breath. Part 2 of this conversation. This one is maybe a little bit more relevant for most of you, and it is regarding inspection items and defect repairs and requests. So I'll give you the primer on this. Let's assume we're using a NABOR standard contract. FAR is very similar, but let's look at NABOR specifically. You have, let's say, a 5-day inspection period, maybe a 10-day inspection period. In that inspection period, you found a couple of items. In fact, I think I wrote it down. 20-year-old generator, worn siding. So the siding has been worn down by sprinklers and sun exposure, UV rays, things like that. And so it still works. It's not leaking, but it looks bad, looks really bad. A couple of the other side pieces. Number 1, the generator. It doesn't work. It's 20 years old, but it is there. The seller has not been using it. They didn't even remember about it. They had no recollection. Is that a defect? So let me put a poll out. I think that's a good question. It might be too late for me to do that. We won't worry about it. Let me know in the chat feature if you think that is a defect. So that's the 20-year generator. Doesn't work. Seller hasn't been using it. It's not disclosed. It wasn't even promoted on the marketing materials, but buyer found out about it on the inspection. Secondarily is the siding repair or siding condition. It's not leaking. There's no moisture in the house. It just looks terrible. It's cracking. It's similar to like a broken roof tile, maybe. In that circumstance, interestingly, it was disclosed on the seller disclosure form. You know, is that a defect? Now, the buyer put both of those on the buyer election seller response form. So that form, as you're probably all very familiar, let's see if I can pull it up really quickly. I may not be able to. So that form allows the buyer to share the inspection report and then elect for the seller to either give them a credit or have them repair it or do some sort of hybrid of the two. And then separately, the seller can respond by saying yes or no. All right, Larry, you get the win. Larry says the generator is a defect. Yeah, it's a defect. And I assume most of you probably felt that way anyways. The interesting part about the generator scenario is that the seller didn't even think about it. The seller, it wasn't on their mind. They haven't used it in 20 years. I don't know if it works or not. It's still a defect. It's almost like if you never used the dishwasher, the buyer doesn't really care about that. Does it work? That's what they care about. So in the NABOR contract, FAR contract, I think both of them would say that this generator is a defect. So the buyer asking for it to be repaired is key. Now here's the trick. Line 316, and my dad is pointing out this as well. here's how we want to respond to this. So number one, if you're representing the buyer, it's a defect, you should list it on the list of items to be repaired or to get a credit for, and ask the seller to fix it, or ask the seller to give you money. That is your prerogative. You should be able to do that. Separately, you're the listing agent. How should the listing agent respond to this? And line 316 is really great. So our recommendation, line 316 says that the repair of the item shall not exceed its fair market value for a working version of that same item. So a 20-year-old generator that is working is worth what? I don't know, but we could probably get an estimate. We might be able to go on eBay. We might be able to ask the maybe the generator repair person and say, what do you think one of these things is worth if you were to find it online? And you get a number. Now, what I love is my dad's suggestion, which he says, double it. So the generator comes in at $1,000 for a 20-year-old generator that would be working. It's $1,000. If you double it to 2,000, it would be hard for a buyer to argue that you're not giving them fair value. And then you go and you get an invoice from that generator company. You just say, give me two things. Give me the cost to repair, and give me your estimate on what it's worth. Or maybe a third thing, give me the invoice for a brand new system. What would it cost to replace it with a brand new system? And then we would recommend you contact us and let us help you with this last part, which is how you're actually going to respond to the buyer's request. So in that scenario, we would say, we accept the generator as a defect, attaches an invoice to repair it, which we believe exceeds the fair market value of the item. The fair market value, we got an estimate, see attached. We are willing to double it and offer that as a credit so that you can then buy a brand new unit at your behest, so whatever you would like to do. That's a really safe way to make sure that the seller keeps this deal together and also maintains goodwill with the buyer. My dad also referenced 10 days to respond. So one of the things that we like to do is we don't want to give the buyer too much information before they put their second deposit down. So the second deposit should be placed down before you make this very generous offer to a buyer, because we want the buyer to have a little bit more at risk when you are negotiating with them, so that you can build a little bit of leverage with that buyer. You can say, look, you've got both deposits down. Let's say it's $1 million deal and you have $100,000 down. I think the buyer is going to be more likely to stay in the deal if they put that full 100 down versus just 10,000. That first deposit might be too low to make them follow through with the deal if you're not just replacing the generator. The key on that point is, yes, it's a generator, but doesn't mean you have to fix it and replace it. It means that you are still able to limit your replacement or repair to the fair market value of that unit. Now, to the next point, the siding. Kim says she thinks it's cosmetic. She nailed it. That is cosmetic. It's not leaking. It just looks really bad. Also, interestingly, it was disclosed. It was disclosed to the buyer by the seller on the seller disclosure form. Now, in my hypothetical, the disclosure was prepared and provided to the buyer prior to going under contract. So it was in the MLS ultimately, or it was a part of the contract when it was originally signed. So obviously the buyer can't say they didn't know about it. It was given to them up front or even earlier. And that's the key. If the buyer knew about this ahead of time, it's not a defect. Secondarily, this probably wasn't a defect anyways. It just looks bad, it's cracked, it's, the paint is worn down, probably not a defect. But in that scenario, the seller's got two things to say: I can safely decline to replace the siding, knowing that I disclosed it ahead of time and it's not technically a defect. So it'd be hard for a buyer to argue and be successful on their arguing. Now, the hybrid of those two questions. The hybrid is, what if they had disclosed the generator as not working ahead of time? I think that would have been best. If they had disclosed the generator is not working in the seller's disclosure, if they had removed it from the listing, or if they just removed the generator altogether and simply said the house is wired for a whole house generator, buyer will have to, install their own or something along those lines. I think you could turn it and use that as a marketing opportunity to say that this, you don't have to pay for an electrician. Like it's already lined up. You don't need a gas specialist. The tank is there. That could be a huge benefit as opposed to doing nothing about it and then leading it to, what's the buyer going to ask for and how difficult are they going to be about it? That's a really key thing. And so that's a really special thing to remember. Let's see, there's another question. When the seller's responds to the buyer's election for credit, can the buyer counter offer an amount? It's a wonderful question. It's tricky. So here's the key. If you do anything short of accepting the buyer's request on that form, the buyer might be able to terminate. So let me share with you how this works. So the form says you can accept, counter, or reject the buyer's request. And then right below it, it says that if you do anything but accept, the buyer can terminate. Because a counter is a rejection and a new offer. So that gives the buyer the ability to terminate. Obviously, a rejection would give the buyer the ability to terminate. So that's why I asked that you reach out to us if you find yourself in that situation. If you're representing a buyer or you're representing the seller as a listing agent, use us to help craft your strategy to protect you, to not doing too much, not practicing law, but to help you and create value for your clients so that the fingers don't get pointed in the wrong direction. What I would recommend in that scenario is, let's say the seller did want to counter, or the buyer wanted to counter. Pick up the phone and you ask. That's what you do. You say, hey, buyer's agent, really, we appreciate you sending the inspection report and your request. Let's go over each line. Number one, the generator, it wasn't disclosed. You got me there. Can we work out a credit? I've got an invoice, I've got a repair estimate, but we'd rather just give the buyer a credit so that they can use that money to maybe replace it sometime in the future. And test the waters, see what they're going to say. That would be great. And then I can help you draft an amendment where we actually do it. And then, or you could even tell the buyer's agent, say, could you please resend a new form asking for this credit and these repairs, and then we will sign it. The seller has 10 days to respond to a buyer election. We got a lot of time to actually play that and let that go through. And in the meantime, the closing date is approaching, and that creates its own bit of leverage. Now, if the seller responds for the credit, can the buyer counter offer for a different amount? Absolutely. I just would be careful about when you sign the form. And I would do it over phone, or I would send an amendment that's signed by the buyer saying that the seller shall give a credit of, let's say the buyer had offered 3,000 credit. The seller is now offering 2, so I'm going to send an amendment saying 2,500. That this shall satisfy the defection repair request if signed, something like that. But I want you to lean into us. Let us help you with that stuff. I think that's where we can drive a lot of value. My dad also mentioned that you could send in a letter. We've done that for clients as well, where we don't use the forms. We have a response that's formulated by attorneys. It can have more formal, people appreciate the formality of it, and they'll be less likely to fight us or to think that they can negotiate with us. If that is something you're interested in us helping you with, please lean into us. All right, so 2 big topics. Those are kind of fun ones I really like. I appreciate you guys staying on for this whole time. If something like that is coming up, if you have one of these topics that you'd like to address, or if you wanted to share some of your experiences, I'd love to hear from you. And in fact, I will send out a poll at some point in the future asking, what is the #1 thing that you've learned just in the last 12 months, maybe, that you're going to use in your business, hopefully for the rest of your career. So that's something I want to always add to my repertoire, add it to our checklist, and use that to help other people as well. So thank you, all of you. If you want to catch up on this video or any others, you can go to YouTube for this, and I'll send out the link afterwards. But it's just youtube.com/Christian Ross. But thank you all for joining. I really appreciate it, and I look forward to seeing you more. Happy holidays to everybody. Bye, guys.